In fact, both our social web stories are sort of cautionary tales, or be careful of what's coming down the pipe. Things that might be happening now that you're not even aware of is sort of where I'm going with the first one. And this is a post that you did, Josh, at your Bowtie blog page, Bowtie Law blog page, about requesting social media in discovery. And just for you to bear in mind that a lot of our listeners, probably most of our listeners, are not lawyers, but people interested in technology law and policy, and hoping that we can enlighten them as to how things in their lives might work should they come into contact with the judicial system in one way or another. And I think it's probably news to people that social media in discovery is even a thing, that should you get into a legal dispute or a law enforcement related activity, many people might think that, hey, if I'm posting privately or to a small group of people non-publicly on the web, that I'm pretty comfortable and confident that audience isn't going to be wider. You know better, don't you, Josh?
Yeah. Welcome to the world of party admissions. So there's a huge body of case law where there are requests for people's social media. Frequently, you'll see them in, say, like a personal injury case, and somebody's had physical injuries and they can't do anything anymore. And this has happened multiple times, there somehow is a video of them riding a mechanical bull on their Facebook page after the accident. And that's rightly requested in discovery. That's happened more than once. So if you're in a lawsuit, don't be stupid. Lawyers need to talk to their clients about, hey, don't post stuff on Facebook about the case, or if you do have injuries, you just don't, be dumb. Think before you post.
Don't be dumb. I think that's our perennial tip of the week here at This Week in Law, but this is just another flavor of it.
Yeah. Think before you do something. And so, like, going back for like the last almost a decade, when these started happening, you would get horrific requests for production from either defense counsel or plaintiff counsel wanting all social media, period. And that's just a massive fishing expedition. And of course, we're like, no, there's the rule that it has to be relevant. You can't just go out and ask for somebody's, entire Facebook profile. And because of the volume of requests that were coming in, Facebook actually created that download feature. What was I? Probably around 2009, 2010, because they got tired of requests coming in for it. And an entire industry is built up with tools that can go out and collect social media. And when that happens, you should then figure out what's relevant. So you can conduct searches on what's been downloaded and look for whether it's tweets or, on Tumblr, whatever, that information can go out and be captured. We see cases come out frequently because when there are requests for production, there's usually a battle, an objection of some kind, saying it's overly broad or it's seeking confidential information. And lawyers have gotten smarter over the last few years with how they request a social media profile. And this request that was in this case is actually, I thought, a good one, or at least better than the ones I've seen over the past 8-9 years. But, they wanted produce all postings related to any type of physical or athletic activities from June 6, 2014 to present on all social media websites, including but not limited to Facebook, Instagram, and Twitter. I think that's a pretty good request. The court, used its authority under proportionality and to help narrow it even further, and it was modified to refer or relate to the physical injuries the plaintiff alleges she sustained as a result of an accident, and any treatment she received therefore, or to reflect physical capabilities that are inconsistent with the injuries that plaintiff alleged suffered as a result of the accident. Those have come into play in different cases that I've seen. Frequently, defense counsel will want to impeach a plaintiff who has a personal injury case, because again, there's either the mechanical bull riding video or pitchers playing frisbee, stuff like that. And while that can actually be very helpful to defense, it could backfire badly if that information relates to a period before the accident, before something bad happened to someone. Other ways that this could come in could be like in construction defect cases, because if somebody lives in a house that's moldy or has water leaks, they're going to go onto Facebook and complain about it. And when they do that, they're creating material that's relevant to the case, because they're talking about the condition of the property. We've seen it in criminal cases where bad guys are stupid and they'll go out and break into something and then post pictures of it on Instagram, and that ends up at the arraignment. So there's a lot of funky, weird things that are happening where this evidence is sneaking in a variety of different ways.
It's interesting you raise construction defect. I used to do one or two construction defect related lawsuits back at the beginning of my practice. And I remember the 10-year statute of limitations that we have in California. I assume it still applies. This was a long time ago I was doing these cases. But one thing that would come up is if you were on notice, you only had a limited amount of time to bring those claims. So if you're posting on social media that there's something wrong, and then you don't take any action about it. And this could apply in any number of situations where there are statutes of limitations that keep you from suing. Someone could go to your social media and say, I'm sorry, you don't get to sue about that because you knew about it way back before the period of time that you would have been allowed to sue. So something to be aware of in your social media postings. One related thing I was wondering about, Josh, from your post here is whether parties, if everything's public, I can see where someone in discovery might be trying to get at things that you hadn't posted publicly because they don't have access to that. But if everything is public, if you're the responding party, can you come back to them and say, I'm sorry, that you shouldn't make me go through all this stuff. It's all public on the web. You go find it. Who has the upper hand there?
I do think you have a good argument that it's publicly available. And if I were defense counsel going up against a plaintiff who had a public Twitter account and was publishing things left and right, and public Facebook, and was making public statements, we'd go grab that and grab at least the public facing information, and then probably have there's a variety of tools that can use that, whether it's something as basic as a screenshot, which people do in like copyright cases, trademark infringement, like businesses posting something on their Facebook fan page, and somebody just takes a screenshot of it, to the more advanced software that can go out and grab it, and then you have an expert who can testify about how it was done. So I would definitely do that if I were defense. If I were plaintiff, and talking to my client, I would have them work with our expert to go out and have all that data collected, because the expert then could log into their account with their username and password and grab everything, because we know we're going to have to go through that and identify what's relevant, whether it supports our claims or defenses, or whether it hurts us. We need to know that, and I would do it that way for my litigation strategy.